The high-stakes legal drama surrounding the constitutional question of whether Donald Trump is eligible to hold public office continues because a draft appealing the recent Colorado District Court ruling just dropped. And in the words of constitutional scholar Laurence Tribe, the case against Trump's eligibility is bulletproof. But will the Colorado Supreme Court agree? Before we unpack all that, if you haven't yet, please hit that like, subscribe, and the alert bell. All right, folks, at the risk of beating a dead horse, we have to talk about this because not only is it relevant to the 2024 presidential election, independently, this is the single most important constitutional question, at least in modern history, if not all of United States history. So as a bit of a recap, I just want to quote the Section 3 of the 14th Amendment, the relevant part of the Constitution at play here. So again, this comes from one of the Reconstruction-era amendments. It was ratified in 1868, and it says, "No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same or given aid or comfort to the elements thereof, enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such a disability." That is the part of the Constitution at question here. Now, last week, one of the many arenas in which this lawsuit or this question was being litigated, which was at Colorado District Court, they held that A, Donald Trump is legally and literally an insurrectionist. That's no longer a matter of opinion. That is the opinion of the United States legal system. It is a fact, and anyone who says otherwise is an idiot, a liar, or ignorant. But that same court also held that even though Donald Trump is an insurrectionist, he can't be barred from the presidency or barred from public office because the court doesn't believe that the presidency is necessarily bound by Section 3 of the 14th Amendment, that it applies to basically every other office in the United States in which a constitutional oath is taken, except the presidency. And so Laurence Tribe, who I mentioned earlier, the preeminent constitutional scholar, this is what he had to say about the logic.
Let me underscore the importance of something that Judge Ludig said. The idea that the most powerful office in the land, described over and over again in the Constitution as an office under the United States, should be exempt, would make the Constitution into a sick joke. What is it? It's an office over the Constitution rather than under. That is apparently what Donald Trump thinks. He has said he would terminate the Constitution. In fact, the net result of this holding is that all underlings are bound by this disqualifying oath, but because Donald Trump used the words as the Constitution required him to use, preserve, protect, and defend, and didn't use the word support, we can treat him as having taken the oath with his fingers crossed.
Professor Tribe is absolutely correct. It's just absolutely self-defeating on its face. So we have a copy of the appeal filed by the Citizens for Responsibility and Ethics in Washington, the nonprofit organization that helped file the original lawsuit. They drafted an appeal. We're not going to read the whole thing, but I did, and I highlighted some very important parts. We're going to go through this in chronological order, so there may be a bit of repetition, but I think it's really important. Again, they begin with an introduction. They found that January 6th was an insurrection, and they also found, the district court did, that Donald Trump did indeed engage in insurrection. But the court held that Section 3's disqualification rule does not apply to insurrectionist former presidents, nor to any insurrectionist running for president, in effect that this office alone is above the law. The Constitution explicitly tells us over and over that the presidency is an office. The natural meaning of officer of the United States is anyone who holds a federal office, and the natural reading of an oath to support the Constitution includes the stronger presidential oath to preserve, protect, and defend the Constitution, right? Because these things are synonymous. As common sense, there would be no reason to allow presidents who lead an insurrection to serve again while preventing low-level government workers who act as foot soldiers from doing so. And it would defy logic to prohibit insurrectionists from holding every federal or state office except for the highest and most powerful in the land. Section 3 does not say that. The framers did not intend that. Trump is disqualified from holding office again. So again, we're going to scroll through this. I'm going to highlight specific parts. Again, this is the argument that the appeal is making. They found that the district court, not only did the district court rule in favor of petitioners, so themselves, on every factual issue necessary to disqualify Trump from the ballot, but it also found for petitioners on every legal issue necessary to grant the petition save for one. Basically, they're saying that the court upheld basically every factual argument offered by those saying that Trump is not eligible to hold public office. But nevertheless, the court found that Trump was not disqualified under Section 3 of the 14th Amendment for two related reasons. First, because it doesn't apply to individuals like Trump who had only taken the presidential oath of office before engaging in insurrection. And two, because it doesn't prevent even oath-breaking insurrectionists from becoming president. Again, just flatly absurd. So then they remind everybody, listen, during the court case, our expert was Gerard Maglioccia, a law professor specializing in constitutional history. He has authored extensive peer-reviewed scholarship on the 14th Amendment, including an article on Section 3 before its recent spike in scholarly interest. His work has been cited by courts and the Congressional Research Service, and he's testified as an expert in a prior Section 3 case. The district court admitted Maglioccia as an expert in the history of Section 3 of the 14th Amendment. In contrast, they say that Trump's expert was Robert Delahunty, a retired constitutional law professor. He has no published peer-reviewed literature on Section 3 and admitted he was not claiming to be an expert in the history of Section 3 of the 14th Amendment. Their guy was just a general constitutional scholar, which is great, but his expertise was eclipsed by the guy saying that Trump is disqualified. But it goes so far beyond that. Delahunty, by contrast, took no position on whether the presidency is an office under the United States, but acknowledged that the preponderance of scholars agreed with Maglioccia. Basically, even Trump's own witness agreed that those saying that Trump was ineligible for office, that most scholars agree with that perception. On cross-examination, Trump's witness admitted that he too would be inclined to think that the president is an office under the United States, given that the Constitution repeatedly refers to the office of the presidency. So even their own witness is actually supporting the factual case and the argument offered by Crew here, okay? And we're going to keep going. Again, we're not going to read the whole thing. We're just going to go through, I think, parts that are really important. Okay, so number one, we know the presidency is an office under the United States because the Constitution repeatedly says so. The Constitution refers to the presidency as an office 25 times, and it gives examples. Section 3 thus applies to the presidency. It prohibits disqualified individuals from holding any office, civil or military, under the United States, using deliberately broad language that permits no exceptions. Other constitutional provisions using the phrase office under the president, office under the United States make clear that the phrase covers the presidency. If the presidency is not an office under the United States, then a president could, the argument goes, simultaneously serve as both president and a member of Congress, even though they're prohibited from doing so. Accept emoluments or even titles of nobility from a foreign sovereign, even though they're prohibited from doing so. Hold office as president, but no other federal office, despite being previously impeached and removed from office. Because if you're impeached and convicted and removed from office, but that only applies to federal officers, well, then you can be president again. Serve as a presidential elector in his own reelection. Face a religious test as a qualification for his office, again, even though the Constitution prohibits all these things. These outcomes would have been unthinkable to the Constitution's framers, okay? And they cite case law that says rejecting reading of the Constitution that would have resulted in so gross an absurdity it could not be imputed to the framers of the Constitution. Meaning if you're going to defer to what the framers intended, you can't just create this thing which is so obviously contrary to what they intended, okay? And again, they point out that even if you want to complain that the presidency wasn't specifically named in Section 3 of the 14th Amendment, it doesn't matter. There would have been no reason to specifically enumerate the presidency because it so clearly falls within the general language of any office. For the same reason, they argue, it's unsurprising that Section 3 doesn't specifically mention Supreme Court justices. They, too, are covered because they hold offices. Okay, and then they point out that technically parts of the Constitution imply that senators or representatives in Congress or electors for vice president and president are not offices, right? So that might be why the framers of the 14th Amendment went out of their way to specifically enumerate those offices, but not the president and not Supreme Court justices. So, keep going. Let's see. Congressional debates over Section 3, so basically the debates in Congress in the 1860s at the time that this was being debated and ratified also reveal a clear intent to cover the office of the presidency. In the Senate debate, Senator Reverdy Johnson of Maryland asked why former rebels may be elected to president and vice president of the United States, and why did you omit to exclude them? Senator Lot Morrill of Maine responded, "Let me call the senator's attention to the words, or hold any office, civil or military, under the United States." And then the first guy, Senator Johnson, replied, "Perhaps I'm wrong to the exclusion of the presidency." "No doubt I am." In other words, Congress questioned whether the presidency was an office under the United States and determined that the answer was yes. Nobody in the debates later suggested this reading was wrong, so nobody disputed that interpretation at the time. And again, they emphasize because at one point they referred to a deleted version of the earlier amendment in which the presidency was specifically named. So Trump was making the case, well, hey, listen, in a previous version of this amendment, they did mention the president and vice president and then cut it out in the final version. And again, the crew makes the case, listen, according to case law, the Heller decision in 2008, this is the words from the Supreme Court, it's always perilous to derive the meaning of an adopted provision from another provision deleted in the drafting process, meaning you can't hinge your interpretation of the final product on an earlier draft of the product when it was deleted, because these are two separate things. But they also make the point that if you do want to defer or refer to, the earlier version, the earlier draft provided that those who had engaged in rebellion would be ineligible to hold the office of the president or vice president. And it confirms that the presidency was understood to be in office. And it also highlights Congress's desire to exclude rebels from the presidency. Okay? But it goes beyond that still. They talk about how contemporaneous debates also reveal a consensus at the time. The Section 3 disqualified people like Jefferson Davis, who was the presidency of the Confederacy, right? He was the antithesis of Abraham Lincoln. Contemporaneous debates at the time confirmed that Jefferson Davis was meant to be disqualified from ever running and holding the office of the presidency. As a matter of fact, during the ratification debates, supporters defended the proposed amendment precisely because it would exclude Davis from the presidency. So that was one of the reasons why Congress voted to pass Section 3 of the 14th Amendment. They wanted to keep an insurrectionist, Jefferson Davis, from holding the office of the presidency of the United States. And so, again, it goes into more detail. They cite other examples of how people at the time said it would be absurd at the idea of Jefferson Davis ever being able to hold the office of the president. Section 3 disqualifies all who engage in insurrection after having previously taken an oath as an officer of the United States. This applies to Trump, they argue, because his presidential oath included a duty to support the Constitution and because the president is an officer of the United States. It mentions that the Constitution contains 2 oath of office provisions, but the president takes a unique one, which is even stronger than the general one for all other federal officers. And in his oath, he says, he or she, must, to the best of his or her ability, preserve, protect, and defend the Constitution of the United States. By swearing the stronger Article 2's presidential oath, Trump necessarily also undertook a duty to support the Constitution. By definition, one who defends something supports it. And they cite examples of dictionaries before, back in the 1770s, before the 14th Amendment was ratified, as well as examples from dictionaries published at the time of the ratification. To preserve, protect, and defend is to support. They are substantively the same. Trump's expert admitting that as a practical matter, the obligation to defend the Constitution includes the obligation to support. So again, even Trump's own witness copped to that. Yes, when Donald Trump took the presidential oath, he was, as a practical matter, as a substantive matter, taking an oath to support the Constitution. So, and then they make the case, if anything, that a former president broke an even more demanding oath would provide more reason why Section 3 should and does apply to him. And again, it cites other examples. Federal judges at the time charged a grand jury that Section 3 is not limited to those whose oaths used the precise words of the amendment to support the Constitution of the United States. Basically, a judge at the time is saying, listen, the way we're interpreting this amendment is if an oath substantively is about supporting the United States, then it counts under Section 3. And again, it goes into details about whether or not the presidency is an officer. As Professor Tribe pointed out, this is absurd to question this. Both text and history establish that the presidency is an office under the United States. The conclusion also resolves the related question of whether Trump was an officer of the United States. A public officer is simply one who holds a public office. And again, it cites examples from the 1700s, the 1800s, one who is in an office, a person commissioned or authorized to perform any public duty. The structure of Section 3 confirms this understanding. Section 3 has a near total symmetry between the persons disqualified by Section 3 and the positions from which those persons are excluded. Just a near perfect symmetry for a reason, okay? Again, it goes on. Judicial decisions at the time of the ratification of the 14th Amendment confirmed that an officer in Section 3 meant anyone who holds an office and swears the oath. Again, it cites examples. They also cite the example of Attorney General Stansbury at the time, who was a ratification or Reconstruction era Attorney General in the United States, where his understanding of Section 3 and his understanding of the presidency of the United States referred to it as an officer in its most general sense without any qualification. Again, it cites examples. Thus, the reason is apparent for including all officers of the United States and for making disenfranchisement more general and more comprehensive as to them, because he's like, the purpose of Section 3 of the 14th Amendment is to keep people who swore an oath to the Constitution from ever holding an office to it. Again, you can't be trusted with that sort of public office. So it meant everybody who was an officer of the United States who swore an oath to the Constitution, not like certain cherry-picked examples. In other words, no formal federal official who broke their oath could be trusted to hold federal office again. And again, it goes on and on with numerous examples. And they also point out in this case how the district court in Colorado, when making this decision, cited Attorney General Stansbury's opinions. And because at the time there was no Supreme Court case contradicting him, and President Andrew Johnson's cabinet affirmed Attorney General Stansbury's position, this was the highest law of the land, as they were legally binding. Andrew Johnson's cabinet approved Stansbury's opinion and directed the Union Army to follow them. Short of a U.S. Supreme Court opinion directly on point, contemporaneous opinions from U.S. Attorney General Stansbury, adopted by the cabinet and implemented by the U.S. military at the president's command, are about the best historical evidence one can get. And again, it goes in examples. Officer was widely understood to be president. They cite examples about how President Washington, its usage extends back to the founding, when George Washington was described as the first executive officer of the United States. The President of the United States would be an officer elected by the people. It was also firmly established in the 19th century. Presidents were regularly called the chief executive officer of the United States, including Jefferson, Jackson, all the way down to Grant and Garfield. Again, it goes on and on and on, how they're especially often called the president the chief executive officer of the United States in terms of the 39th Congress, which again ratified the 14th Amendment. So it keeps going on. It talks about court examples too, where they have referred to the president as an officer of the United States. Let's see. And then I think basically we're at the conclusion. Again, they reaffirm that when interpreting the Constitution's text, courts are guided by principle that the Constitution was written to be understood by the voters. Its words and phrases were used in their normal and ordinary, as distinguished from technical meaning. The simplest and most obvious interpretation of the Constitution, if in itself sensible, is the most likely to be meant by that people in its adoption, or meant by the people in its adoption. That's the opinion of the United States Supreme Court and how you're supposed to interpret the Constitution. Exempting, this is where it gets interesting too. They point out, listen, exempting the president and presidency from Section 3 of the 14th Amendment would also conflict, with the broader constitutional design. The qualifications for the presidency are the most stringent in the Constitution. They point out how that particular office, you have to be 35 to be eligible for the presidency, which is the highest age bracket. You have to be a citizen from birth to be president, as opposed to a citizen for merely 7 years for the House and 9 years for the Senate. Basically, the idea was the framers intended for the highest set of standards to apply to the presidency because it was the most powerful office. So this idea that Section 3 would apply to all these lesser offices, but not the most important and powerful one, runs completely contradictory to what the founders intended. No court should adopt an interpretation of the Constitution that has such absurd results unless strictly compelled by unambiguous text. Fortunately, in this case, the text and history all comport with common sense outcome. Section 3 does not disqualify oath-breaking insurrectionists from nearly all public offices except the highest one, nor does it give a unique free pass to insurrectionist presidents. And so it concludes, Donald Trump must be held ineligible from public office. Again, I encourage you to read this through the entire way as I did. It's 67 pages. It's shorter than the district court opinion. But folks, this is overwhelming. I mean, it really is. You have such a bipartisan consensus from not only progressive and left and leaning liberal constitutional scholars, but also conservative constitutional scholars as well. J. Michael Ludwig, William Baud, Michael Paul Stokes, people like that. I mean, it runs the gamut. And the amount of constitutional scholarship, the amount of historical citations, the fact that Trump's own expert during the litigation of this particular court case basically deferred to, Cruz witness, Professor Maglioka, on all the pertinent facts, makes this overwhelming. It makes no sense that insurrectionists are kept from less powerful, less important, less dangerous offices, but not the most important, most powerful, and most dangerous one. This is currently being appealed. The Colorado Supreme Court, I would be shocked if they didn't take it up, but there's no telling how they may rule. But seems to me that the legal case is pretty freaking overwhelming. Let me know what you think in the comments.